Morning, testing, testing. Good morning, testing, testing.
Yeah, sounds good. I can hear.
Perfect, perfect. Thank you.
I'm here. Can you hear me?
Yes, yes.
Okay.
Good morning, team. We're going to wait for Dr. Abraham, who was literally walking in the door as we speak.
Day, can you hear me?
Yeah, it's Alberto. Yeah, I can hear.
Okay.
Yeah.
If you guys can email me the background. I don't know why I don't have it on my list anymore, but I don't.
Okay. Let me check it.
All right, good morning. We're on the record. Good morning. I would like to call today's hearing to order at 9:35 a.m. Let the record reflect that I'm participating via just cause and no one is in the room with me. I'm traveling on business for another governmental agency. And the exception is allowed under just cause. Relative to Ms. Verdugo Peralta, hearing board member Verdugo Peralta is appearing remotely via Zoom today as a reasonable accommodation for a qualifying disability under the ADA pursuant to Attorney General Opinion number 23-1002 dated July 24th, 2024. I'd like to lay a motion on the table to allow her to participate via just cause as presented on the agenda.
Second.
Is there a second? Moved by Ali, second by Dr. Abraham. Any further question or discussion on that?
Just, I thought for just cause you don't have to vote, only for the emergency provision you need to vote. You don't need the majority of members to say aye or no.
Well, I'm sorry, she's actually under emergency. She's under emergency circumstances.
So you're changing into emergency circumstances then?
Yes, she's under emergency circumstances. That's what's on the agenda. We can always amend that. We can always amend that, but I just want to be very clear because under the Attorney General's opinion, which references federal law, so we're very clear, she has no cap. So
A little confused
can-
here.
we can do it. We can do it under just cause.
Well,
We can do it under just cause.
oh, I'm sorry. Mr. Ali,
Go right ahead.
you break up a little bit, just so you know, sometimes the connection, you're interrupted, but John heard you. And I don't have the agenda in front of me, but did it say the reason for her appearance, Mr. Chavez?
Emergency
No.
circumstances for AB
Right.
2449.
Okay.
Right, but that's being amended to a just cause provision. And remember, what I stated was she's participating as a reasonable accommodation.
What I was trying to point out was if Mr. Ali is through just cause, we don't have to vote for,
Right. And
And
we've
for only
established
for
that.
Ms. Verdugo Peralta, if she's using the emergency provision, I believe we have to
Right.
vote then.
And on the agenda is emergency. And what I'm saying is, I'm going to say it again, she's participating via just cause as a reasonable accommodation for a qualifying disability under the ADA pursuant to the Attorney General Opinion number 23-1002. Ms. Verdugo Peralta, are there any individuals in the room with you?
No.
Okay, let the record reflect that. All right. Okay. We're proceeding forward with the hearing that's before us. Are there any individuals, Mr. Chair, Mr. Clerk, who signed up to provide evidentiary testimony or non-evidentiary
No.
testimony during no public comment? Oh,
No.
okay. Thank you very kindly. The case before the hearing board today is USA Waste of California, El Sobrante Landfill. Case number 51339-3, modification of final compliance date and extension of variance rules 20033002. There are a host of exhibits I'd like to mark. These are petitioner exhibits. Number 12 is stipulation of place on consent calendar with exhibits. Petitioner exhibit 13, supplemental declaration of Christian Colline, Colline. Respondent exhibit C, declaration of Peter Homsey, Homsey, and then the hearing board exhibits, or one exhibit rather, HB2 email thread regarding consent calendar dated 7/15/2025. There are no additional exhibits to be added.
Mr. Chair, I was going to point out that the Exhibit C from the respondent, we didn't get an email. I don't know if Ms. Verdugo Peralta got it or not, but it was here when we came in today, the Exhibit C. So it was not email, I believed.
Mr. Clerk?
I have to look into that. Give me 1 second.
And you're referencing the responded exhibit C declaration of Mr. Peter Homsey, right?
That's correct.
Yeah, that document is online. That document has been available to the public and is online. It was uploaded. So that document is available to all. Any other questions relative to that?
No, I was just pointing out I didn't get the email on that.
I can only see on my email. I can't see if it was sent from the front computer.
Yeah, I mean, we do have a copy here, so I was just questioning whether Ms. Verdugo Peralta has it or not.
But the document was uploaded, so I would make an assumption that members of the hearing board would review the documents on the hearing board's webpage. Any additional comments relative to exhibits? Hearing none, we're going to open up the floor for discussion on this matter.
Yeah, I want to state for the record that I had not given consent for this hearing to be heard on the consent calendar, and I cited my reason why it shouldn't be, because of the public nuisance potential and pursuant to Health and Safety Code and hearing board rule. It says that, and I can read that for the record, that that's why I said it should not be on consent. Just as I did the last time for this hearing, I removed it out of consent, and then we found a lot more information when the parties came in as to the number of complaints and so forth. So that, just for the record, I wanted to say that I did not agree for this matter to be heard on consent because of the hearing board rule for let's see, B5, hearing board shall not include any matter of consent candidate for operation under variance or the variance expected to result in violation of Health and Safety Code 41700 nuisance. So, and I know the chair overruled it, didn't give a reason why. I didn't see any reason why he's overruling. But nevertheless, I'm going to then propose, we had a general meeting last week and there was a new rule adopted, even though I didn't vote for it. And but for section C4, if a hearing board member decides at a hearing for which a matter has been placed on consent, and that he or she has substantive question related to the matter, and so forth, he may request the chair for the matter to be rescheduled. So I'm making that formal request to reschedule this hearing to where it's not on consent, where both parties are present to answer more detailed questions, substantive questions, specifically on the nuisance potential and also what's going on with the ETLF conditions at the landfill. If I might just bring everybody back up to speed, we have a similar situation at the Chiquita Canyon. Amorisco and Chiquita came to us initially because of the issue with the flare. That's the first indicator that the sulfur content is very high due to the high DMS being generated. So they came, but then we found out at Chiquita, I mean, that it is a ETLF condition. That is the first time we have probably heard of it. That's what's going on at the landfill. So El Sobrante has a very similar situation as we discussed the last hearing, all the symptoms are there, maybe on a much smaller reaction area, but all the symptoms are there. So, so that's the concern, why are we not giving it the level of urgency, scrutiny for a serious event occurring at this landfill and doing this matter on consent without hearing from the parties directly. So anyway, that's my motion. I mean, you can, take whatever action you seem fit.
Well, you made a motion, there's no second, so the motion dies. With respect to the concerns raised by Mr. Balakapulan, yes, emails were sent for which are encased in exhibit number 2. Emails were sent. I then had the clerk's office to engage both parties with respect to the concerns. The concerns were provided, declarations were tendered. Both sides, the petitioner as well as the respondent, both sides, the petitioner and the respondent, replied accordingly, for which has all been encased within the exhibits. His concerns were proffered, they were heard, and I made a decision to proceed forward based upon the facts as provided. And so if you reference all of the email traffic, including members of the general public, if you're so inclined, you will see all of the communication that transpired. And so the decision was to move forward with the matter of consent today. Are there any additional comments relative to the matter at hand? Any other members of the hearing board? All right.
Yes, Dr.
Is there a
Abraham.
motion? Dr. Abraham.
Yeah, I would just like to also respond to Mr. Balagopalan's point, and why I didn't second or support the motion. Definitely agree with what Chair Ali just mentioned in terms of the concerns were raised. We saw your email, we saw the responses, both from the petitioner and from the district. There still is this stipulated, decision or modification of abatement, order of abatement that we have before us. And that's the difference, that there was a lot of work done. There was a stipulated agreement between those two parties. That gives me as a hearing board member more ease to proceed with this as a consent calendar item and with the adoption of our new consent rules. But I definitely, for the record, would like to state clearly the emails are here laid out. The concerns that Member Balagopalan brought up, I believe, have been sufficiently addressed by all those that responded. And then the communication that we would proceed with consent calendar. So in some ways, I just want to also recognize that this is the process that we discussed back in the last general meeting. And this is how we hope that it would be operationalized. And as one of the hearing board members, I feel sufficient moving forward with this item on consent. There are lots of points that we can definitely get into the actual case itself, but I did want to discuss specifically that process and agree with what our chair said. And I hope that board member Balagopalan feels like his issues were addressed. Not sure if that's true or not.
Well, that's not true, because I would have loved to question the inspector, because the inspector's declaration doesn't make sense to me, because he said that 21 complaints were received for odor nuisance because the odor received has not met the threshold for public nuisance under Rule 402. There's no specific threshold you have to meet. There's a threshold to get a notice of violation. He's conflating the two, I believe, and I would love to ask him what the difference is. He thinks, you need to have at least 6 people sign. Typically, if we heard, about the odors before they can issue a notice of violation. But if you look at 402, there's no specific threshold. Any member of the public can complain about odors. And it's like I said before, in the last hearing, there were 70 complaints that the petitioner had listed in the declaration. When the inspector came, we found there was over 500 complaints during the same period of time. Mr. Weiss astutely said, oh, it's average 1 a day, but that's, if you look at the other way, there's a 1 a day complaint coming. If you look a day coming due to this landfill operation, it's not elevated to a notice of violation, granted because the last violation was 2023, but there is a potential for a violation if there are more than 6 people, or the inspector observes it when he's there, the strong smell, and gives a notice of violation. So there's a difference between when he says threshold for public nuisance. I don't understand the difference of, and the other point I want to reiterate is, again, this is area of concern, at least for me, is because we know this is ETLF event. You got settlement, you got hydrogen production, you got all the symptoms of an ETL event that's occurring, and we had put a lot of condition and burden on Chiquita to control it, to minimize it to the public. And I would love to hear what the other agencies are doing in this regard too. Or if I'm assuming the DTSC, the LAA, Cal Recycle, Regional Water Quality Board, and Riverside, that is are all looking into the matter. We don't have any information. If you recall that the DTSC actually declared an imminent danger from Chiquita. I don't know if they're proposing to do the same. They had come up with some very good proposal to mitigate by using geomembrane cover. I don't see anything like that addressing the ETLF event. The flare is symptomatic. This is what happens when you have a high DMS. There's a permit condition limiting the sulfur content going to the flare. So that's what has brought them to the hearing. But underlying that is all the other associated problems going on with the landfill. We shouldn't be ignoring it. We should be addressing it. And we seem to be, in my mind, just not addressing it.
I hear your concerns about ETLF. I saw the emails and the concerns that were raised there too, but I also have concerns about us, I guess, biasing our considerations of this matter with everything that we went through with Chiquita Canyon and that ongoing situation. I feel like that I do want to be careful about not having that unduly influencing how we are approaching this case. And so, yes, I hear those concerns. Yes, the ETLF issues, but I have a feeling that us using Chiquita as the example and then basing our decision here off of that is also problematic.
The reason I referenced Chiquita is because of the ETLF condition. So they have the same ETLF condition at this landfill.
Ms.
Ready to make a
Ducal-Pralt?
motion, or whenever you want.
Thank you.
Yeah.
Thank you, Mr. Chair. Can you hear me?
Yes, we can hear you loud and
Okay.
clear.
Yes. Well, the way I also look at it is that there was, from the legal point of view of the AQMD, the attorneys for the, if they did not want to have it put on consent, they would have said so. And they have been on the receiving end of all of the documents from whether it was the party opposite, AQMD, if it was the landfill people, or if there were members of the public, or if there was another agency that said, no, we need to hear this, we would have it before us, and we don't. The fact that the attorneys are not having a problem with it being on consent, I think, also speaks volumes. So, I'm listening to everything and reading everything that is sent to us, and I did not have, I think I wrote in, I did not have a problem with it being on consent for those reasons. Nobody else on the legal side is having a problem with it. So therefore, if there's nothing else that was presented between then and now, I think we're fine with it going on to consent. I understand what Mr. Balagopalan is saying, and I respect that, but I think the majority of the people who are involved in this case are fine with it being on consent. So therefore, so am I.
Thank you. Mr. Pyrmont, would you like to tender a motion?
Certainly. So in this matter of case 5139-3, request for modification of existing variance based upon the material submitted with the consent request, including the findings and decision order proposed therein, and all the evidence there in the findings of fact stated in Exhibit 2 to the stipulation that we got good cause to find that the 6 conditions for a variance are still being met, and that therefore I move that we accept the Exhibit 2 proposed findings and decision in order, including the conditions set forth therein.
Second.
Is there a second? Second by Dr. Abraham. Any further question or discussion on this motion? Hearing none, Dr. Abraham, your vote.
Aye.
Ms. Verdugo Peralta,
Aye.
Mr. Balakapalam,
No.
Mr. Pearman.
Aye.
All the votes in the affirmative, the motion is hereby agreed to. Thank you very kindly for all of the work put into this by the clerk's office, as well as both sides, petitioner as well as respondent. Thank the members of the hearing board for your diligence. Look forward to seeing you soon. We are officially off the record and adjourned at 9:55 a.m.
And I just wanted to make a comment and verify the fact that there is no hearing tomorrow, correct? It's been
Correct.
moved to August 20th. Thank you,
All right, folks,
everybody.
have a great